Thank you for keeping it. Good morning, Kenya. If you're just joining us, welcome. My name is Jane Wamboy, and you are in time for the first discussion for the day. And right now, we just want to talk about intellectual property. And if you are a creative out there, this discussion is definitely for you because it really impacts your industry. And I have two fantastic guests with me to help me with this discussion. I'll start with the lady to the extreme left. She is Caroline Ratemo, who is the CEO at Ratemo and Company Advocates, and also a director at Africa IP Registrars. Karibu sana.
Thank you, Jen.
All right, and to my immediate left, we have Kenneth Essendi, who is a director at Africa IP Registrars in charge of operations, finance, and marketing. Karibu sana.
Asante sana.
And as always, please feel free to be part of this discussion. You can do so via our communication platforms. Our SMS line is 20154. It is on the top left of your screen. Do leave a name and location. We'd love to know where you're watching us from this morning. You could also get onto Twitter. The hashtag is #GoodMorningKenya. My handle is the Jade Mumboy, and our official station handle is at KBC Television. Any questions, comments, or clarifications that you may be needing, feel free to send them through. We'd be absolutely glad to help you in whatever way that we can. So we want to quickly just help our viewers understand, when you talk about intellectual property, what does it really entail? And maybe we could start with the basics, with the definitions of even the word intellectual property in itself. Let me hear from you, Kenneth.
Yeah, actually, intellectual property is more of what you have, and it will become an intellectual property if you protect it, right? So intellectual property from my side, basically I'll say it's protection of the very many ideas we have. Yes.
The intangible properties that you may be having as a result of creativity.
Yes.
All right, and maybe we could also hear from you, Caroline. When you talk about intellectual property rights, from a legal point of view, what do we really mean?
Thank you, Jen, for having us. Sure. Intellectual property, it basically is the creations of the mind and how we express them. After we express them and we protect them, now they become intellectual property, which is protected. So we can have many ideas, but as long as they are not protected, they are still not yet under intellectual property rights. Once you protect that idea, and intellectual property has different facets. So depending on how you express that idea is how determines how you're going to be protected. For example, we have artistic works and literature. That one falls under copyrights. So two people can have similar ideas, but they express it differently. For example, you can have a song by Daddy Owen and another song by another artist. They give her the same storyline, but they express it differently. So you find that because the expression is different, the storyline is different, maybe drawings or soap operas, they have the same storylines, but they're expressed differently. So when you protect them, they become protected by the law under copyright law.
So when you talk about copyright, it is protecting an idea, how it is expressed.
How it is expressed.
Not the idea exactly, but the expression of the idea.
Is the expression of the idea.
Fantastic.
Yes.
All right.
Yes.
Now, that's just one of the different kinds of protection or property rights that there are. And I understand there are a few others.
Yes, there are a
few.
few.
Tell us a bit about that.
Yes. After copyrights, we have trademarks. Trademarks is about creation of the brands, protection of the brands that we create. For example, we have slogans, we have logos, we have business names, we have combination of words that mean something to you, especially it can have commercial value. So when you protect that, then it gives you the right to use it. Actually, something to do with trademark, with the intellectual property, it gives you exclusive protection against other people to some extent and for a certain period of time.
All right.
So basically also most of the time, people really wouldn't take it as fast as possible when you tell them you need to protect your brand. You see, in a way, when you protect your brand, you'll protect it under some statutory fee and all that. But basically, people will escape that. And you see, once your rights are infringed and you realize you don't have those rights, that's when you'll come into light and say, my rights have been infringed. And there's nothing you can do about it. Once you've not protected them,
is done.
yeah, there's nothing you can do about it.
All right.
Yeah.
And we'll be getting to some of the challenges that, come along with intellectual property. Yes. But let's quickly just finish up on the different kinds of, intellectual property categories that are there.
Yes.
We've talked about copyrights. Now we are on trademarks.
Trademarks.
Yeah.
Yes, so the trademark also has some limitation because you're protected to the extent of the class that you protected. Because
so
the law, there are different classes of trademarks, such that if you protected your trademark under furniture, then you're protected to that extent, such that you can use a certain word that you're dealing with furniture, and somebody uses the same word but dealing with maybe shoes.
Something else.
Something else.
All right.
But then they are protected to that extent. So you can have similar names as long as they don't bring confusion in the public domain. Then you can use it. Trademarks are protecting you to that extent that you've actually disclosed with the registration bodies.
Okay. Yeah. Now, I'll probably also talk about the record labels. Yeah, being the entertainment industry, you realize we have record labels that haven't trademarked their names. They still trade and they still get revenue out of it and all that, but they don't know. They really don't know they're supposed to protect what they have for it to become viable. Okay. Yeah.
All right. And also still on trademarks, usually see under the logo or the slogan, there's usually like a small circle with TM.
Yes.
And some have R.
Yes.
For the benefit of our viewers, what do those stand for and what do they mean even in the first place?
It means that name or that brand is protected under the trademark laws
so the
of
TM
Kenya.
Stands for trademark?
Yes, it stands for trademark, yes. It means it's trademarked. So if it doesn't have, probably either the person who trademarked that did not advise the person how to use it, or they just don't know, or it's not actually protected.
And the R?
The trademark, it just means trademark. The
TR,
TM. Yes, the TM.
And the R means registered or what?
Yes.
All right.
Yes.
All right.
Yes. It's a registered trademark.
All right. The other category is patents.
Yes, the other category is a patent. Yeah. Patent is the highest form of protection in intellectual property. It has a very high threshold when it comes to how to get it protected, because for you to get a patent registered, you have to prove that it's a new idea that has never been done in the whole world. Yeah. And registering a trademark takes about 2 years because all the offices in the world have to communicate to search.
A trademark or a patent?
A patent.
Sorry. A patent. Sorry, a patent. So the patent offices in the whole world will have to communicate and be sure that that idea or that thing that you've come up with has never been done before.
It's
also,
novel.
It's novel. Then it has to have industrial application such that it can be used in the industry that you've come up with. Not something that you can just produce it now. It cannot be used in the industry. It is not for commercial use.
It doesn't have commercial value.
It doesn't have commercial value.
Right.
So those two things are very important.
All right.
Yeah.
Now, another one is...
we have industrial designs.
Industrial designs.
Yes.
And trade secrets as well.
Yes.
All right.
So industrial designs, they protect the aesthetic value of an idea of a property, not actually the functionality of the property. Maybe colors, beautification, shapes, it's somebody owns that kind of a creation. So the law protects them to ensure that at least they own that value because it comes from their own intellect. Intellectual property is about thinking, what you come up with from your own intellect, and then being able to express it, and then it has value for you. You can be able to use it exclusively, and it can give you, a business sense also.
All right.
Yes.
So under all these categories, they all have to have commercial value.
Yes, it has to have a commercial value. Yes.
All right. Now let me come to you, Kenneth. When we talk about intellectual property, especially in the creative industry, you're in the entertainment industry. What are some of the biggest misconceptions and mistakes that you've come across from the creatives when it comes to protecting this intellectual property?
Most of the time you realize many people don't really know where to find the information, and probably you'll find Kenya intellectual property hasn't really picked up the way it's supposed to pick up. That's why we actually trying to bring this up so that we can sensitize other people out here who are watching us. They be able to protect what they have. What you have, you see, ideas get to make big dreams, right? Like ideas are bigger than even. So basically I've seen, like, you'll find record labels, they have not protected their work. You see, like the copyrights, you can take all the copyrights for a whole record label, and then you collectively protect them.
Okay.
So the challenges have really found out dealing with so many artists, they have not protected their work. So they're not even, that you see, once you haven't protected your work, you're not the owner of that work.
So there's a very big gap in terms of even the information out there in regards to
the
how
information
to go about
out
this.
here.
Okay.
So that's why we're trying to sensitize people. You're supposed to actually do this. It's for their own benefit.
Yeah.
So like, you see, once you collectively trademark your logos, you copyright your work, you know you can attest to what your company is. Most of the time we hear Kenya saying, oh, we don't have airplay, we're not getting revenue and all that. It starts from us. Legally, like the whole entertainment industry should start right now also investing in intellectual property. That's where we shall actually start the battle from.
All right.
Yes.
Now, when just on the same breath, you know, he's talked about record labels, and when it comes to record labels, there are artists who work there, and they are, most cases, the original creators of the music, the ideas. Now, in that case, who has the rights to the song? Is it the record label or the artist?
Well, copyright is all about authorship of a song, and it has many parties. We have the authors, we have the composers, we have the arrangers, we have the performers, we have all those people that come up together. We have the producers, you know. So what happens is that for us to know who owns a song, there has to be something that connects these two people. And that is a contract. And before we even get there, the copyright has to be registered. Immediately, the person who comes up with that information is there.
So the original source. The
original source.
Okay.
You copyright that idea of the song. And then when you go to record the song, you have to have a contract between yourself, the producers, and the other people who will now, that contract will now inform how we are going to share the proceeds of this copyright. Because you will not own everything, because many people are also involved. What percentage do I own? Is it what percentage does the author own? What percentage does the producer own? And all that people. So that by the end of the day, we can say maybe the producer has 50% or 20%, the author has this, performer has this percentage, and all that. But the copyright is supposed to be owned by the creator, the originator of the idea.
And in this case, it shouldn't be a gentleman's agreement. It should be written.
It should be written.
By word of mouth.
It should be written.
Because I think that's where most of our artists go wrong. You just agree verbally.
Yes.
And then there's no witness to attest to that or a record to prove that there was an agreement.
Yes.
And in that case, you cannot even support your case in case, you know, your rights are violated.
Yes.
You don't have any backing for your case.
Yes. Yes.
So never go for a gentleman's agreement, in as much as it's a gentleman's agreement. Choose to have it in record.
Yes.
Yes? Yes.
Sorry to interrupt.
No worries.
Yes, but there is something that happens, actually, most of the time. There are so many people who do contracts out there. They're not certified people. So probably this something, if you're doing a contract, it's not just about you doing a contract and then going to sign with wherever that someone is. Because if something goes wrong, you don't really have someone to say, I was a witness to this contract. So there's a gap in between. Right,
and also
there.
You need to know the details of the fine print in that contract.
Yes.
Don't just go in blindly.
Yes.
And you know, maybe just on that breath, just, you know, from a legal point of view, how advisable is it to have property rights, intellectual property lawyer when involved in such cases?
Just before I answer that, another challenge I wanted to state is that the artists, the parties involved in all this, sometimes they just decide to air the ideas anyhow. Like, for example, you have a good idea, you just send it to email, through email to somebody. Or you just call everybody, start discussing it without even protecting it first. By the end of the day, by the end of the day, it's a race for registration of rights. Somebody else will run with it and go with it. You understand? Also, when you're doing the production of the song, without the contract, you find that the labels, the producers, and the artists, they come up, they clash. And then you produce a song, it is given many, many names, and then you find that the producers are earning from some side names of that particular song. You understand? So, because by the end of the day, you never protected this work before you started. There was no plan, there was no strategy. You understand?
Yeah.
So lack of strategy in the way we produce our works is also a challenge, because we tend to assume a lot. We make a lot of assumptions. By the end of the day, you find that people are using your work and you're earning nothing from it.
Yes.
You have really thought about it, you have sung, you have put a lot of effort, but everybody is using your song. Everybody is using, even TV stations, sorry to say, they are seeing, you know, they get the work online and they start using it. There's nothing you can do about it because you never protected it.
And that is why our creatives get, you know,
Yes.
languish in poverty, yet your work is doing so
Yes.
well out there.
You are
So
a big name, but only on TV.
The
because
work
you're
gets
not able
diluted.
to.
And you don't earn from it.
Yes, and you don't
And yet
even
it has
earn.
commercial value.
Yes.
All right.
Yes, so it's very important to have a lawyer, because there are laws in Kenya that protect intellectual property. For copyright, it's a bit simple. Actually, you can register copyrights without a lawyer. Okay. The only problem is that when the concept is not properly captured, and you know, in terms of, because when you start with a lawyer, the lawyer is going to guide you even on the contracts that you're going to do, the management contract that you're going to have, the endorsements that you're going to have and all that. It's a process. When you don't use a lawyer, then you can just have something very minimal, protected or limited, or in the wrong way. But you can do actually copyright registration without a lawyer, because it take you about 1,500 when you don't have a lawyer.
Right.
You will need to pay 1,000 bob at the Kekobo, and then 500 for a lawyer to attest your documents, and then you're good to go. But again, you need to consult. You need to consult with a lawyer, because it's a process.
Yes.
For you to become that brand, even with that one song, you need somebody to work with you and tell you, when you have the song out and you copyrighted, this is how now you go managing the brand using that particular copyright.
Don't go in blind.
Don't go in blind.
Yeah.
Then for trademarks, of course, and for copyrights, it's going to take about 2 weeks. And you're done. And you're done.
Fantastic.
Yes, but for trademarks, it's going to take you about 6 to 8 months. You spend about 16,000 statutory fees that you're going to pay to Kipi. And that one, I'll highly recommend that you use a lawyer. Why? Because the classes, and also how to use the related rights when you register a certain class. There's also the period of waiting. Sometimes it can get a bit complicated because of the time you're going to wait. The stages of registration are there. You need to search, you need to apply, you need to go through examination stage, advertisement stage. And actually during advertisement, you can have objections, which can take us to court, you know, so that we now defend it, and they say this is ours and all that. It's a bit of process. So that one, I would advise that it's good to use a lawyer. Okay. And also now the issues of renewals, because a trademark will protect you for about 10 years.
Oh.
10 years,
they
which
all
is
have
renewable.
a time frame attached to
it.
it.
Yes, they have a time frame attached to it to protect you about 10 years, which is renewable. So it's good to have somebody just to ensure that they work with you in the journey.
All right.
For patents, it takes about 2 years because of the, you know, the process of checking with all the registration offices in the whole world, and a bit, the documentation is a bit lengthy also in patents. It will protect you for 20 years, about 20, 22 years. So because of the documentation for a patent, you must use a lawyer and all that. A copyright will protect you for a lifetime.
Your lifetime?
Your lifetime plus 50 years.
After your death?
After your death.
All right.
Yes.
All right. Now maybe you could just tell us a bit about, you know, where we stand as a nation in terms of protecting our intellectual properties, since you're in the industry.
Probably, I'll honestly say we're really lagging behind on this one. So that's why we're actually trying to sensitize people. I've worked with so many other different labels, including right now we're actually working with Kaka Empire. Yeah. So we really have a long way to go. But for now, I really say for those one who have protected it, it's not something you do it once and then you leave it. It's something you'll do it over and over again. So I'll say for those ones who haven't done it, they should really get time and get to protect their work so that we can move faster. And then those one who have done it, they be able to do it over and over again. There's a case, there's a time we even copyrighted Wakadinali songs, right? We copyrighted like 35 songs, and you see right now they have other songs they need to copyright. So this is a process. It's more of a journey, and the more you have your work done, copyrighted, you have your brand like branded legally. At least you have something tangible. You can tell people, I have something of my own that I own.
Okay.
Yes.
Now, let me just come to you, Caroline. When you talk about, intellectual property, you find cases where, just as you said, you send somebody a sample of your song, you post it on social media, and somebody else takes it and goes ahead and writes it or patents it or just makes it legally theirs. What do you do in such a case if you are the original author of that idea?
Okay.
Or what even happens in such a case?
In such a case, first of all, it's good to note that copyright is a recommendation. It's not a must for you to copyright a song to own it. It's actually a recommendation. But for you to have all the rights on the song, it's very important to copyright it. Because once somebody has already produced a song and is out there and they are not copyrighted it, but you're able to show, you prove by evidence that actually this song originated from me. Because you can have, there's a way of auditing information. There's a way you can give proof that actually this is how I came up with the song, the first person. So the person who actually released this is not the right person to own. You are able actually to challenge that, but you must have evidence. You must have evidence. The danger is that those are things that are going to bring you into a place of conflict. And instead of doing that, why should you not why should you not protect it in the first place? There's a way you can own it regardless, but it will bring you to a place of conflict because you have to prove it that actually you are the one who came up with the issue. And the other person can also have the same issues. So it can take you not in a good place. So the best thing is to just protect it, even though copyright is actually automatic. I would say copyright is automatic, especially when it comes to production songs.
All right.
Yeah.
So if you don't copyright it, somebody takes it and goes, they copyright it. It will be a first come, first serve basis.
Yes.
Because you were the first one who went with the idea.
Yes.
And you protected it.
There's nothing you can do about it.
There's nothing you can do it.
Once somebody has, it will become a very long process after somebody else has already copyrighted it.
That's it.
All right. Now let's quickly talk about, when it comes to the rights of publicity under something that you have copyrighted or you have patented and somebody else wants to use it. How do you go about such cases? Let me hear from you, from your experience where somebody wants to use maybe your name or your image or your likeness and you have protected it. How do you go about such cases?
You've protected it, right?
Yes.
Because you wanted revenue out of it. So probably someone will come pay you for them to use your trademark or anything you have that you've protected. So it also gets you revenue out of it. If you haven't protected it, you see the cases, even people will go perform and they will be denied they'll be denied being paid. You get, this is a situation that comes out of, I wouldn't say it's ignorance, maybe it's lack of information. So probably you see those are the repercussions that comes with that.
Okay.
Yeah, from my point.
All right. Also from a legal point of view, when you have the right to everything that you have protected, but somebody would like to use that. How do you go about it legally speaking?
Yes. Okay, legally speaking, there's something we call licenses. There's something we call assignments. And there's also something we call franchise. Why franchise is because maybe somebody has come up with a brand, they've protected it, they've made it commercially viable, and you want to duplicate it. So we enter into an agreement called a franchise agreement. If it's music or wherever, you do assignments of the rights or licensing of the rights. It's a binding contract that you enter between the parties. You agree on the period, how you're going to be paid for the use of those rights, and how it's going to terminate. So don't just have something that is of value and you start dishing it out without having a solid contract to protect you.
Okay.
Yes.
So when it comes to the rights of publicity, there has to be a binding agreement that you have allowed them to use. All right.
Yes.
Now let's
at a particular consideration, and it has to be very specific. How long?
There has to be a time frame indicated.
Yes.
All right.
Yeah.
Now, maybe you could tell us a bit about, now the process of registering or going about these processes. What are the relevant bodies? Because you had mentioned them very briefly.
Yes.
Maybe you could tell us a bit about this, that our viewers can know where to go if you want to copyright your work, if you want to patent it, if you want to get a trademark. Where do you go where to get all these services?
Okay. In Kenya, for the law is the Intellectual Property Act, and when you want to register a copyright, you have to use Kekobo, that is the copyright board. That is where you go you download the forms. They're actually everywhere online. You download, you fill the right information, you go and pay, you submit your documents, and you wait for the certificate.
Okay.
For trademarks and patents and industrial designs and everything else, we go to KIPI, that is Kenya Industrial Property Institute. So that is where you file all the documents, you make all the payments, you wait for the period that is required, then you get your certificates.
All right.
Yes.
Now, for artists out there, when your property has been infringed,
Yes.
what is the first place that you need to go? Or what is the first action that you need to take?
You actually need to use a registered lawyer, of course, a viable lawyer. And you see, like, you'll probably find someone will be there for you. You need to make sure that the person who is attending to you is a certified person to actually do the right thing for you. So I'll basically advise artists out there, like, they should get used to using someone whom they trust and someone who is certified. They shouldn't just use anybody else for them. That's for their own benefit. Yeah. Use someone who is certified for you to also feel you're certified, and you also feel protected, and you also feel you have the rights to use what you've actually created.
Okay.
Yes.
Now, I have somebody who here sent me a text who's asking, what is moral rights? Because somebody has used that terminology in my work, and I don't really understand what it means. Moral rights in intellectual property.
Rights of attribution or something. Maybe I can talk about the rights of attribution. Okay. Is for example, in employment perspective, you find that sometimes you can be employed to create creative designs and work, which is copyrightable or which is protectable, which is able to be protected. But now you find that the only reason why you've been able to come up with that work, your agreement is based on an employment contract between yourself and that person. So what happens when you leave that employment? Yet you're the one who came up with that work. You understand? So there's that, the moral right of attribution is that you must be able to identify or disclose the person who actually created that work, even if they're not the owners of the work. Because you find that when you come up with that work, there's a clause that says all the copyrights belong to this company. Yet you're the one who came up with the work. It's very
fine print.
Yes. So it's very important that you understand, even when you're getting employed to come up with such things, it's very important to understand what the contract entails in your employment and what it means when you leave the work. Because most of them, they even limit you. They put a competition clause that you cannot be able to do.
Once you leave.
Yes, once you leave, maybe for 5 years or for 3 years, you're actually limited to doing such a work, or even identify yourself or something like that.
All right.
Yeah. So, but according to the law, that's the right you should not take away from the person who created the work.
They should be
it
benefiting one way or the other.
Yes. It's important to have them identified with the work.
Okay.
Yes.
Now, for all the creatives out there, maybe you are in the entertainment industry and you have worked with them. Maybe just a word of advice to them when it comes to just once you have a project or an idea out, why should protecting it be the first thing that you do?
What I'll basically say, as we've discussed, and if you're watching us from home, actually thank you for watching. I would probably say protecting your work will make yourself easier, and you'll also have to earn from what you have. So most of the time we wouldn't have people complaining, I'm not earning from what I do, because actually now the government even also knows you're the sole owner of the rights of your project, right? So any other project out there, may it be music, may it be a film, yeah? You see, other people even produce feature films. They even sell them to TV stations. Do you have even a contract for the people around you? Do you have a contract on how you'll share the revenues out of the film? Do you have a contract with the TV stations, how you'll get the revenue out of the TV station, right? And do you also have a contract on how you'll also, like you see, like you'll get a soap opera from somewhere or get a feature film from Kenya. So we have people, the parties involved. You'll probably state, you'll be able to show this feature film from this date to this date. So you're supposed, the contract should bind you in a way, you're supposed to, the TV station is supposed to air the feature film for that particular period. Once it has elapsed, they're not supposed to air it. Like, we should have guidelines on what we have. If they want to air it because the public demands it, let them pay for the revenue.
Yeah.
Yes.
All right.
Yeah.
Legally speaking, why is protecting yourself the first thing that you need to do, especially when you have this intellectual property, because it's intangible?
Yes.
You can't say ndio hii nimekaa hapa hii ni yangu.
Okay, I think the first reason is because ideas, everybody has an idea. And it's all about who comes first to register. Because it's about first come, first served. We don't protect ideas. We protect the expression
Of the idea.
Once you have the idea and you've not expressed it, then don't expect protection. You understand? So the other thing is that intellectual property infringement of rights is very automatic when it comes to enforcing them. I don't have to prove that I lost anything for me to get compensation for infringement of my intellectual property right.
Yeah.
So it gives you a very high level of protection when it comes to infringement of the rights. And also, the way the protection is so high is also the way you lose very fast when you've not protected it. If you've not protected that idea and you've given it out there, then sorry. I'm sorry to say, there's a case I was handling about some university students who came up with this issue of kitambulisho, this thing that we were doing registration. Huduma number. Yes. I was actually dealing, they came to me and they told me, you know what, we are the one who came up with this idea. We shared with the government. We did all those things. But by the end of the day, they came, they took our idea and they went and implemented. I told them sorry, because when they came up with the idea, actually they have everything. But when they come up with the idea, they never protected it. They never protected it. After now the implementation is ongoing, is when they're telling me, oh, what do we do? You know, somebody else came, they presented it, they gave all the documents, you know, something just happened and they lost it like that. You know, if you don't protect your idea, even if it's as big as what, you will lose it.
Yes, even startups are really vulnerable to them being like the rights being swapped or maybe taken away from you, the startups. So basically I would advise anybody coming up with a startup, if you have something, if you have an idea, come out clear, protect it. It's your idea, protect it. That's a merchandise. It means everything to you and it may become a very big idea. And you see, if you have someone who established and comes to and then takes away your idea, you know, there's nothing you can do about it. So I'm also saying, besides her saying the bigger brands are supposed to be protected, I'm also crying for the startups. If you're coming up with something, package it very well, protect it, move on, and you'll benefit from it.
Protect yourself legally.
Yes.
Intellectual property cannot be quantified, that it can be put in here and say, this, it belongs to this one. You have to protect it by whatever means possible. So before you put your work out there, especially for the creatives, because they're the ones who really get affected by, you know, infringements of rights when it comes to intellectual property. Protect your ideas. If it's a song that you have, protect it before you put it out there. If it's an idea that you have come up with, protect it. If it's an invention, protect it before you put it out there or before you even pitch it to a potential investor or someone that you're looking to invest and help you in the journey. Have a binding agreement moving forward. Just be safe legally so that in the event that something goes wrong, you have the law to back you up. All right? Well, I think that brings us to the end of this conversation, but maybe what would be your parting shot to our viewers in regards to intellectual property and the rights that come along with it?
I would say that let us not assume. Let us not assume that we are not able to do this. Many people think getting a lawyer is very expensive. That's not. Many people think that it's very complicated. It's not.
The lack of information.
Lack of information. Just approach somebody. We want to demystify this.
Yeah.
We want to work with that person who is from nowhere, you know, somebody who does not even understand what this is. Please look for somebody. They're going to walk you through. It's not expensive. It's not complicated. It's not for the rich. You know, there's that notion that I cannot afford.
Misconceptions.
Misconceptions. And you find that I was talking to some people from Kibra, some artists, very renowned artists from Kibra. And just because they think it's a big thing, they never thought that they can do it. You know, by the end of the day, they become big brands. They have very big songs, but they don't benefit. Yes. You meet them on the streets and you just, you know, your heart is in pain because if somebody had just given them little information, they would not be where they are today. So take that bold step, look for information, get somebody to work with you, and you're going to enjoy the benefits of your creativity.
Especially now with this social media era.
Yes.
Yes.
Your parting shot.
Yes, yes. Thank you so much for that. And I'll shift a bit from the intellectual side, and I really want to also mourn with our national heroes. For the past 3 weeks, you know what has happened to Kenya. We've had Laboso, we've had Ken Okoth, we've had Bob Colimo. So we actually also mourning with other people out here, with their families, and we send our condolences right away, right from this place. And then now I'll move to the intellectual side. I'll probably say ideas, it's everything. And probably my idea, like my dream, is tied to your dream. So if you protect your idea, you're also protecting what I'll earn from. So if we get to protect what we have, we'll also have to boost the economy, and we also boost ourselves to better people.
All right.
Yes.
Well, there you have it. If you are a creative, once again, please take that bold step and protect your work right from the beginning, from the inception of the idea or the invention or the formula or the recipe, whatever it may be, as simple as it may be. You never know, one day it could blow up into something great, and somebody may benefit from it, and you are there just languishing in poverty because you did not protect your intellectual property. So we do hope that you are better positioned to make wiser decisions when it comes to protecting intellectual property. And of course, we are still open to any questions or comments that you may be needing in regards to this discussion. We'll be having consequent discussions in regards to intellectual property, just to help better help you understand and know how you can go about these processes. Well, I have been speaking with Caroline Retemo, who is the CEO at Retemo and Company Advocates, as well as one of the directors at Africa IP Registrars. Thank you so much for being with us.
Thank you.
And of course, the gent with me on set, he is Kenneth Essendi, who is also our director at Africa IP Registrars, in charge of operations, finance and marketing. Thank you so much for being with us this morning.
You're really welcome.
Now, Good Morning Kenya does continue. We have more interviews coming up in not too long. But first, we want to take a quick commercial break. But remember, hashtag Good Morning Kenya on Twitter, at KBC Television is our official station handle. My handle is Ajeno Boy, and my colleagues at Raymanyara, at Dorina Range, and at Ramaguko, those are their social media handles. And of course, our SMS line 20154 is the number. Don't go anywhere. We'll be right back.